welcome our visitors and honorable members, members of the Secretariat. I want to take this opportunity to welcome all of us to this joint committee sitting of Committee of Lands, Physical Planning, Housing and Urban Development. And therefore, honorable members, before we begin our meeting, I just want to inform our visitors that it's a practice that we start with a word of prayer, and therefore I want to request that let's make our prayer. And this prayer is official. It is not inclined to a certain faith or religion, but it's an official prayer as per the parliamentary practice. Let's pray. Almighty God, who in your wisdom and goodness have appointed the offices of leaders and county assemblies for the welfare of society and the just government of the people, we beseech you to be all with your abundant favor as your servants, whom you have been pleased to call to the performance of important trust in this republic. Let your blessings descend upon us here assembled, and grant that we treat and consider all matters that shall come under our deliberation, in so just and faithful manner as to promote your honor and glory and to advance the peace, prosperity and welfare of our county and of those whose interests you have committed to our church. Amen. Now, thank you so much, and the next step is that we want to introduce ourselves so that as we proceed, we know each other, and especially for the purpose of our today's guests. And to start with, I'm Honorable Amos Kiptanui. I do represent Resco's Ward, and I'm chairing, I'm today's chair, and I'm the chair of the Committee of Housing and Urban Development. And I said earlier, this is a joint committee of lands and physical planning, and my substantive co-chair is on other official duties, but I'm privileged to be joined by today's co-chair, whom I would want her to introduce herself, and then Sergeant at Arms, you will assist to pass the mic to honorable members, and then we go to the Secretariat, and then the guests of today, and then we shall proceed from there. Welcome, my co-chair.
Thank you, Chair, and all protocols observed. Good morning. My name is Sarah Malel, member representing Kimumu, a member of the both committees and assisting the substantive chair today, also the Deputy Speaker of Uasin Gishu County Assembly.
My name is Honorable Francis Muyamwangi, a member representing Langas Ward. I'm privileged to serve in both committees and double up as a leader of minority in the County Assembly of Uasin Gishu. Karibuni.
Good morning. I'm Kimani Wanjoy, member representing Huruma, also the minority, Chief Whip in the Assembly.
Good morning, everyone. I'm Honorable Isaac Churchur, member representing Soy Ward and Vice Chair of the Committee of Urban Planning.
My name is CPS Samuel Sawe, member representing Kamagot.
My name is Hilary Kipchumba, member representing Moiben Ward.
Now, to the members of the Secretariat, please.
Okay. I'm Kelvin Mibanda, Committee Clerk, Lands and Urban Development.
My name is Michelle Saina. I'm the Legal Counsel.
From Research Department, Royce Kimtai.
I am Swai, Committee Clerk.
I'm Jacqueline Chepkemei, Hansard Reporter.
David Sum, Public Relation Officer.
Victor Troitit, Sergeant at Arms.
Sharon Kwambai, Sergeant at Arms.
Thank you so much, honorable members and members of the Secretariat. Now, Sergeant at Arms, pass the mic to our guests to introduce themselves, and I think either can lead in the team. It's for them to choose.
My name is Francis Osoro, Manager Films Limited.
Good morning, everyone.
Morning.
My name is Thomas Keegan, Advocate of the High Court of Kenya on behalf of Films Limited.
Okay, thank you so much. Now, honorable members and our guests of today, we want to start our meeting, and therefore, thank you so much, Advocate Thomas Kiken and Mr. Osoro, who is the Managing Director, Films Limited, and therefore, we want to thank you so much for coming to today's session. And also, perhaps we want to apologize that we had invited you before. You were supposed to attend a meeting in some dates back. That was on October 11, but due to a technical hitch, we were not able to proceed, and the same was communicated to yourselves. And therefore, there was an invitation that was second, which was you were sent to on a via letter dated 16 October. And therefore, we want to say thank you so much for your appearing today and coming on time. We apologize for starting a bit late. It was because of some few issues, but we still want to appreciate your patience as well. And therefore, as per the letter, the letter was well elaborate, and allow me to go through our the first letter, which is dated 29 September. And I'm referring to that letter because it had some details, but the other letter was just a reminder that you have been scheduled for another date. So allow me, honorable members, to go through the letter. And this is a letter dated 29 September 2023. Our reference is UGC CS SSEC LHBU volume 5/14, addressed to Managing Director, Films Limited, Bbox Eldoret, and reference is invitation to attend a committee meeting. The above subject matter refers following complaints from the members of the public regarding construction of a building on a claimed access road in between parcel number 9, 8, 7, and 460 in Block 6. The County Assembly of Wasingishu is in the process of establishing the truth on the matter. Pursuant to the provisions of Article 195(2) A and B and Section 18, subsection 1 of County Assembly's Powers and Privileges Act number 6 of 2017 and Standing Order number 184 of the County Assembly of Wasingishu, the Joint Committee on Lands and Physical Planning and Housing Urban Development invites you to its meeting scheduled for Wednesday, 11 October 2023 at 9 a.m. at the County Assembly presence. The committee would like to be furnished with information relating to the ongoing construction on the said above parcel of land. Further, the committee would like to be provided with the following documents: A, allotment letter for parcel number 460. B, BAT development plan for parcel number 460, survey plan for parcel number 460, certificate of lease for the parcel number 460, copy of land register for parcel number 460, permission of development approvals submitted to the relevant authorities. G, other copies of approvals submitted to the relevant authorities or agencies. And H, any other relevant documents signed by on behalf of our clerk, Shadrach Choge, copy to the chair, lands and physical planning, and copy to chair, housing and urban development. That was the contents of the letter dated 29 September. And again, there's a letter dated 16 October 2023. And of course, this invitation to attend committee meeting, it says the above matter refers to our previous letters dated 29 September. Reference number UGC stroke CS sec stroke LHBU volume 5 stroke 15. And 5th October, reference number UGC stroke CS sec stroke LHBU volume 5 stroke 16. We wish to inform you that we have rescheduled the same meeting to Friday 27 October 2023 from 9:30 a.m., which is today, and we are so much grateful. And this letter was sent by clerk to the county assembly, Mr. Shadrach Chowki. So our guests, Mr. Francis Osoro and Advocate Thomas Keegan, that was our communication, and therefore you are here today in respect of that invitation. And therefore, before we start, I just want to inform you that this proceeding is live, and again, you are free to use the two national language to present your submission, English or Kiswahili. And again, if you have any, and of course, we want to believe you came with the documents we sought from you, which I have just read out. And any other document maybe we didn't request, but you feel it's of great help to this committee, we shall appreciate. And whatever you want to share with the committee, you will hand over to our secretariat, seated on your right hand, and then they will pass it to the chair. And again, since the information that you are giving will be relied upon when this house will do its report, and therefore we want to believe whatever you are going to submit is the truth, and therefore as a matter of procedure, you are going to be under oath, administered by our legal counsel, Michelle. And therefore, I want to request that before we begin our session, I want to request Michelle to proceed to administer the oath of the oath or affirmation, whichever the one that they will take it. Proceed. Okay, members, I was being given a brief, and so it's not the only person that will take oath or affirmation is Mr. Francis Osoro. But with the advocate, I've been advised appropriately.
Raise this Bible with your right hand and read this oath loud.
I, Mr. Francis Osoro, swear before God that the evidence I shall give before this joint committee touching on the matters in question shall be the truth, nothing but the truth, so help me God.
Thank you so much, Mr. Osoro and our legal counsel. And therefore, we are ready to proceed. And as we start, now that we have the two of you, it is at your discretion to decide who to respond to what, and that is at your liberty. So, Mr. Osoro and Advocate Thomas Keegan, as per our letter that was written to yourselves, I would wish that you tell us more about the issue beforehand, and it has been elaborated very well in our letter dated 29 September, that there is a public concern or outcry over a construction that is taking place and probably done by yourselves or your client on the said parcel of land. And the reason for the concern is that that is a road reserve or a service lane, and therefore it is in the interest of the public and members of this County Assembly of Uasin Gishu to understand under what circumstances that development is being done and how did you reach where you are, that what used to be a road reserve or a service lane has now mutated to someone's parcel of land. So kindly, I want to give the poll to you to give an explanation on what happened, and more so, tell us about the history of that area. At least in your expression, we need to understand. And therefore, members, I want to request that.
Chair, before you proceed, I think there are documents that were requested amounting to about 9 documents. It could be laid before the chair, then you could proceed.
Okay, that is in order. There are the documents that I read out, 9 in number. I don't know whether you came with those documents so that it will assist us as we progress in our deliberation. Kindly, sir. And as they arrange those documents, I want to request that let's hear from them and then take note of the questions, and I will give you opportunity to ask or to pose the question when that time comes. So kindly, Mr. Osoran, Advocate Kiken, it's now your time to take us through. And with the documents, if you have originals, you can just hand over to our Sergeant at Arms to do a copy, and then he will return the original to you. Okay. So first and foremost, the documents that we sought for, kindly submit through our Sergeant at Arms to the chair.
Okay, thank you, Chairman, for that opportunity, and thank you for the invitation for us to come and explain on behalf of the registered owner of that property, that is Altaf Abdulaziz Batia. As we prepare the documents, first of all, I want to say that some of the documents we have are originals and some are copies. Reason being that our said client has been unwell. She's been diagnosed with she's been sick. He's been sick, and the documents have been kept in safe custody, and it's the reason why, and it's outside the country. Abdulaziz Batia is normally in the UK, and he travels on and off to the country. So we were unable to get everything. Some of the documents we had in our chambers, and the others, they are in his safe custody. So we'll be able to provide what we were able to get. Back to your question regarding the history of the property, or rather the question as to how did Mr. Abdulaziz Batia came to be the owner of the property, yet this property was initially a road reserve or a service lane. The answer to this is as follows. It is not in dispute that initially this property was a public utility. That is not in dispute. What is in dispute is the question as to whether what is in dispute is that this property is currently a private property and is not a public utility as alleged because of the following reason. Mr. Abdul Aziz, in the year 2006, applied to be allocated parcel number Eldoret Municipality Block 6441, which had no number initially, and which is currently alleged to be a public utility.
Okay, please refresh again your statement.
Okay, what I'm saying is that Mr. Abdul Aziz applied to the Commissioner of Lands around the year 2006 or thereabouts to be allocated this parcel of land, this land 6411, which was initially an access road, and applied for the same to be amalgamated with his parcel of land number 611. I'll tell you the reason why he did so. Before then, this lane separated two parcels.
Maybe as you proceed.
Yes.
When did he apply for amalgamation? Do you know the exact time or year?
We through a letter which we also shared with the county attorney and the honorable speaker, and even the lands was in issue, we shared the correspondences between the county commissioner and the lawyer who was processing the said.
Do you have a copy of that letter? If you have, kindly share with us.
Yes, I do have. There's this letter. Yes, we have the 1 second of
Second February 2006.
Yes, that is the letter that captured. I don't know whether it is in the.
Kindly, Sergeant Atam. Is this the letter that you said it was addressed to the county?
This is a correspondence letter
Okay.
showing the conversation or the communications between the Commissioner of Lands and the firm of Kimaru Kiblakat and Company Advocates, which firm was tasked with the process of amalgamation and the process of exchange.
Okay, and before then,
Yes.
in your statement you said there was a letter
Yes.
addressed to probably the county, the speaker.
Yes.
Do you have a copy of that letter?
Yes, we do have a copy of the letter with
Please
the demand.
kindly do it,
We have a demand letter which
maybe as you
Land matters are very sensitive. I don't know the letter that they are giving you, whether they are copies or original, because if they are original, I will not want a situation whereby they'll go out of this house and say that they left one. So kindly, Chair, when you're handling those issues, because they are land matters, them and the Standard Janitam office, because we need every copy, yes, but we don't want a situation whereby they will say we left a copy with us. Kindly, we need to be very careful.
I think they say they have with them. You're looking for it, eh?
I'm not talking about that. I'm talking already what you are looking for. I don't know whether it's a copy or
No, this is something
because
different.
what if they are giving whatever is an original is a copy, should be, if possible, certified to be the true copy, and whatever they don't have a copy, need, under their supervision, need to be done a copy, because we need those copies, because we don't want a situation whereby they will leave this place and tomorrow we'll hear that they left some copies with the county assembly. That is my take, Chair.
Okay, I think you've gotten the concern, and maybe on the letter first.
That is a copy of the letter, which has been acknowledged by the county secretary. It has also been acknowledged by the physical planning, the county attorney, and even the honorable speaker.
Okay, thank you so much. And maybe to the honorable members, the letter that is talking about reliably was shared with this committee. I want to believe so. It was shared to this committee. You know, I could not just admit any other letter, maybe it's a different one. But I want to say that it was copied to the speaker, not addressed to the speaker.
Yes, it was copied to the speaker.
And I don't know, Secretariat, have you done the copies of that? Did you do the photocopies? Did you do the photocopy of the letter that was addressed, copy to honorable speaker, like this one? Check, members, on your files if there is a letter from Kipkorir, Cheriot, and company advocates. The letter is dated, was received by a county assembly on 21st September.
So in that letter,
yes.
Maybe
kindly advocate.
Yes.
Let's allow members to locate the letters.
Okay.
I think they are in their files. Have you located, Honorable Muya? Wanjoi? Secretariat, tell us now. Where are we? Maybe, honorable members, this is a letter, it has a letter of Kipkorir, Cheriot, and Kiken advocates. The letter is dated 21st of September 2023, and addressed to the county secretary. Reference is demand notice over Eldoret Municipality Block 6/460. Our client Altaf Abdulaziz Patia. It was like a demand notice. So maybe, honorable members, I want to request, advocate, do you have any problem us doing a copy of this?
No problem.
Okay. So we shall proceed, honorable members. Let's just listen, and then this one will come later on. Sajinatam, please. No, this copy is in there. Proceed, sir.
Thank you. So this parcel of land that is that was initially a public utility, that is number 441, yes. Eldoret Municipality Block 6/441, was running in between two parcels of land belonging to the same, belonging to Farm Implements at Motor Spares Limited, wherein Abdulaziz was also a director. Yes. So this parcel of land was providing access to Block 7, to parcel number 7. Now, what happened is, at that particular time, Farm Implements Limited was doing in the business of a warehouse.
Maybe I would request that just use FIMS. You know,
FIMS.
members can be confused.
Okay,
what is farm
FIMS.
implements, yeah.
Okay, thank you. So they were doing the business of selling motor vehicle spares, petroleum oil products, and other merchandise at that particular time. Unfortunately, there was a risk of vandalism each and every time for several years because vandals would hide on that line. They vandalize our clients' accessories and even steal money at night. And it was for several years. It had continued for so many years. So we have detailed that. We are very kind enough, and we detailed that in that letter. If you will have a copy, you will understand what we mean. So criminals frequently broke the windows and fire escapes that were along the lane and gained access into the business complex and the warehouse and stole spare parts, oils, and other merchandise. They also stole money that were proceeds of sale and that were to be banked the subsequent days. Again, the area had been converted into a toilet where people would step into and relieve themselves. And it became difficult to operate during the day because of the foul smell that oozed from the lane. The lane also was converted into a dumping site where people dumped used oil, other liquid waste, and other solid wastes. People would be hijacked, marked, and taken to the lane where physical injuries would be inflicted on people. So what happened then is our client took the bold step of now, because it was becoming difficult to operate on that lane. So now FIMS took the bold step of applying to the Commission of Land to be allocated that portion of land so that it exchanges it with a portion of parcel number 435. Because as I've explained, parcel number 610, parcel number 441, which was a public utility, lies between 610 and 435. So what happened is that now, because
Chair. Yes, Honorable Anjoy.
Just something small for clarification.
Yes.
Can you get the specific date and month in which you applied?
They are reference letters which we are sharing. They're even originals here.
Just mention.
There is an amalgamation. There's a letter from the Ministry of Lands dated the 2nd of February 2006. This is an original letter from the Ministry of Lands where the Commissioner of Lands referenced our letter that is dated the 29th of September 2005. And the reference of that letter, which we have been looking for but we've not obtained the same, is R/114/3255/2002. So this thing started even way back in 2002, the application. So, and the Commission of Land said that this should be treated as an exchange, since your client surrendered a portion of parcel number 435 as an access to be allocated parcel number 441, which was originally an access road. And that is the Commission of Land saying that. However, since the area surrendered for new access road, that is 435, is less than area acquired, your client need to pay for the excess area to be acquired. The amount to pay you will be informed. And later, that is what he said. Then finally, the annual rent, as a result of the amalgamation of parcel number 10 and 441 will be reassessed in future. As soon as the above is done, you will be informed of the relevant amount to be paid to enable final documentation. You will also be required to surrender the titles for parcel number 10 and 435 to enable issue you with new ones for parcel number 460 and parcel number 459. This is the letter.
And I want to believe the same is in the document that has been.
Yes, it is.
Okay.
It
yes.
is. It is. Now, it is talking about later. That is on 3rd March. That's a month later. That is on 3rd of March 2006. Again.
Maybe cancel.
Yes.
Before we proceed.
Yes.
You said the letter from your clients to the Commission of Lands. The letter that has been mentioned here. Yes. Your letter reference number R/114 /3255/202 of 29 September. That is the application letter by your clients to the Commission of Lands.
Yes.
Do you have a copy? Or
the reason I've explained myself is that our client is in a medical condition and we cannot accumulate all the documents, but we had to attend this meeting today.
Okay.
Yes.
Proceed.
Then the Commissioner of Lands in that letter talked about giving us valuation of what to pay. So what happened is, in a nutshell, is after the Commissioner of Lands approved the exchange, then the survey plan was also sent to the Director of Surveys in Nairobi, and then he approved also the RIM, and we have also shared that one.
Kindly.
Can I proceed here?
The survey plan is in the document
yes,
that
it is.
submitted.
It is an extract, not the full. It's an extract of that area, and we are also kind enough. We can share. We can have one for your view.
Proceed.
Now, so the survey plan, the Commission of Lands indicated that it would later give us valuation of what will be paid for the portion which was less, because what 435, a portion of 435 that was surrendered for the public utility was smaller than what was acquired.
Maybe cancel.
Yes.
Are you able to point out, this is now the survey plan?
Yes.
Are you able to point out where there is 435? Kindly point to our clerk.
435, you see, this is the survey plan after amalgamation.
After amalgamation.
After amalgamation.
Do you have any document before amalgamation?
Before amalgamation,
yes.
I can state again that we have not gotten that as of now, but given time, we can avail the same.
Secretariat, take note of that. We don't have the survey plan before amalgamation. You know, we could really wish to understand. You said the reason was to access plot number 7. Isn't that so? Plot
yes.
number 7.
Yes.
You see?
Yes.
That road used to
used to give access to plot number 7.
So what you have given us is already amalgamated plan, eh?
Yes.
Yes, yes. Proceed, sir.
Okay. So what happened?
Yes.
I wanted to write all my questions, but I am torn in between the line because step by step, the answers are raising pertinent questions. I don't know at what point you'll give up because he has a substantive answer, but whatever he have answered have raised other pertinent questions that would like to be answered. I don't know at what point.
Okay, thank you. I think that concern is valid. I want to request council that we might not put down all the questions. Even myself, I've been tempted to intervene because we want to get how the sequence of these events. So maybe in the process, I will allow members to pose questions, and we shall progress in that manner, because we might forget because of other issues that will come later. So that's how we are going to engage, and therefore let's allow him, and then I will intervene at some point to allow members to post questions. Please proceed.
Thank you, Chair. So according to that letter for 2nd of February 2006, then the Commissioner of Lands indicated that it will give us a valuation of the annual rent with effect from the 1st of March 2006, and they assessed the same and shared through the letter dated the 3rd of March 2006. And in that letter, he referenced our letter dated the 2nd of February 2006, which I have shared, and say that I wish to confirm that valuation is now complete and annual rent with effect with effect from 1st March 2006 has been assessed as follows. Eldoret Municipality Block 6, 459 is 3,650. Eldoret 6, 460 is 58,000. And then he asked us to furnish them with the original lease for block number 6 and block number 35. And then the rent and rates clearance for parcel number 10 and for 35. Surrender fees for parcel 10 and for 35. Conveyance fees, registration fees, payment of additional premium for parcel number 441. So there was additional premium because the parcel was smaller than the acquired parcel. So there was a premium that was paid of 112,000. This is the amount of 146 assessed less 34 already paid via receipt number D966842 of 8th of April 1998. So payment of 55,000 legal fees for new leases for parcel 460 and 459. So there were new leases also that were issued, because when parcel 435 was subdivided to Hive Hub, the public utility, we got a new number, that is number 459. So, and it tabulated all the payments and gave a total figure of 169,602. So, this is the letter I want to share with the committee, and it is the original. Subsequently, there was a responding letter to that. So, Films Limited through Kimaru Kiblagat and Company Advocates forwarded the payments, that is via the letter dated the 4th of July 2007, saying, we refer to the above matter and your letter dated the 3rd of March 2006, enclosed herewith as requested is the following documents: original lease certificate for parcel number 6/10, original lease certificate respect of parcel number 6/435, rates and land rent clearance certificate in respect of Eldoret Municipality Block 6/10, and rates land rent clearance certificate in respect of Eldoret Municipality Block 6/435. So again, in respect of the fees that had been requested, so in that last paragraph, he said that the fees indicated in your above referred to letter were paid via banker's check number 829,233 for Kenya shillings 169,602, and receipt number this 0503,352 for similar amount issued. Kindly issue the appropriate leases. So this is the letter. that has been acknowledged by the Commission of Lands, and this is the original receipt for the payment of 169,602. So immediately after the payments were made, then the amalgamations were done and the new leases issued for parcel number 460 and parcel number 459. Those are the new parcel numbers. And the other parcel behind was available as a public utility. We have shared copies of certificates of lease for parcel number Eldoret Municipality Block 6/460 and Block 6/435 in that letter and in that correspondence. We have also annexed searches for the said parcels and all the correspondence and the RIM extract. We also later got the green card which we applied, that is the records from the land registry, which was also requested as part of your requirements. Sorry?
Point of order, Chair.
Order, Council. Let's allow an honorable member. What is out of order, Honorable Muya?
There's nothing out of order, but the information, as I had indicated to the substantive chair, the information is too much. And how I wish we could have gotten the direction that we intervene as we go, because we are getting very reliable information. But if we get it all, we are going just to leave some gaps.
To forget what you wanted to.
So,
Honorable Member, we note your concern. I would like to seek your indulgence that he completes the last part that is talking about the green card. And then, Chair, we will allow you now to interject.
Okay.
Sorry for that point of objection. As requested, as part of your documents, so that the Honorable Majority Whip could actually put his point of
order is the minority.
Minority, so
always address the chair through the chair.
Okay, thank you, Chair. Okay.
Okay.
What I was saying before you arrived.
Also, maybe sorry. I know why you said majority whip. Yes, just accept the sitting position of whip. This is just for today, but during our official sitting, it's not supposed.
Thank you.
To sit here.
Thank you for disseminating knowledge to me in terms of the sitting arrangement and the address. So, Chair, I was indicating to the committee that the documents that we supplied unfortunately does not have a green card, which pursuant to your letter we proceeded to apply for the same and we obtained, and we have a share with us showing the history of the property from when it was acquired by Farm Implements Limited to the point of transfer to the current registered owner. Maybe the committee can also have a view of the same. So after the payments were made, as I indicated, that is the payment as per the receipt that I've shared, then what happened is that the new leases for parcel number 460 and parcel number 435 were issued. And to date, later after the same had been issued, that is parcel numbers 460, it was later transferred to the director of FIMS, one of the directors, that is Abdul Aziz, who is currently the registered owner of that property. And to date, he has the lease document for that parcel, and he also has, unfortunately, we have copies today, but given opportunity, we'll also be able to share the originals with the committee if requested. So the reason why we are here today was pursuant to your summons to explain as to how that parcel of land ended up being a private utility, yet it was a public utility before, and we have explained and we have put forth the evidence that this was whereas the community and the people around knew that this parcel of land initially was a public utility. There is documentations and communications between the Commission of Lands and the said FIMS Limited, showing that all the protocols and all the legal procedures were followed in surrendering part of the land for FIMS in exchange of that parcel number 441. So after that, that is when there was that construction that was done. I don't know whether you want me to also dwell in that.
Thank you so much, Council.
Yes.
Now, as I directed earlier, that for the purpose of further understanding, I will allow members to pose questions, and so the members maybe he has gone further, and you might have forgotten some of the questions, but try your best to recall, and any moment it will come up, just you are free to ask. So kindly members, you can have the mic, Honorable Muya, and then Honorable Naomi Serem. In that order, please, Honorable Muya.
Thank you, Chair. The Legal Counsel have given a lot, and I stand guided by your sentiment that in the process of giving his submission, maybe some of our questions might have gone, but we are going to keep reminding ourselves. I want to take you back together with the Managing Director. First of all, I acknowledge and really thank you, the Legal Counsel, about admitting that initially it was a road reserve. Before now, we talk about the new numbers. Chair, I would like us, first of all, because we are in a process, first of all, to acquaint ourselves or to equip ourselves with the truth, with what the ground, how it looked like. First of all, there is what we called PDVs and RIMs. And I think that you did not submit any document to do with the PDP or RIM, because these are some of the documents that you did not access. Is that true? Through the chair? I'm saying land matters, they are guided by special document. That is the PD. It is called PD?
PDP.
PDPs, the approved PDPs. Did you have that document with you? And RIMs, because from where I see it, the document that was shared with us as a PDP, the approved PDP, showed total different numbers. That initially, there was plot number 13, where we know, since we were young, we knew where FIMS were, even when they had a petrol station. The long front part, it was one parcel of land, number 13. And between it and plot number 7, plot number, then it was plot number 4, 5, and 6. There was a road, which you agree it was a road, an access road, which was not properly used, and it became a threat to the business of films. But there were no any other plot. And whatever you are calling plot number 411, it is what was an access road. Are you aware of at what point it ceased from being an access road or a road reserve, and it was given a number as if it is a prop, and you called it, you gave it plot number 411. So I would like to hear, first of all, for you to be very clear, because this investigation is being followed, as you are heard. Everybody is following it up, because we were born in Eldoret, brought up in Eldoret, but today you are trying to justify how it became to be a private land. First of all, whatever you are calling plot number 459, 561, and 4 something, it was an open space. In the PDP that we have, that was submitted to this committee, there were no plots. Whatever you are calling plot number 459, 561, you can be guided by the Secretariat. Would like to know, as a committee, when was this open space allocated as plots, including 459 that you are calling, you are saying it is owned by FIMS. When was it allocated? Because from the map that we have, there were no plots. The only plot that were there is plot number 13. That is the front part of FIMS. There was an access road that you sought for amalgamation. And before amalgamation, it was given a plot number. Would like to know, when was it allocated a plot number? And by who? Of course, this is by the commissioner, but would like that date. And below it, it was plot number 4, 5, and 6. Later, which came to be 7, 8, and 9. But would like to know, when was this open space that you are calling individual, including plot number 459 that you have kept on referring to? When was it allocated to FIMS? Because according to the map that we have, it was an open space. Because why am I saying that, Chair? It is out of this creation of the new plots where they are saying that they surrendered. When did it came to be individual plots before surrendering? Because that is the question. Before you surrender it as a personal plot of FIM, when was it allocated to FIM? Because initially it was an open space. Another issue, Chair, when he was giving his submission, he said that they wrote letters seeking for the amalgamation, for it to be not an access road but a plot. The letter that they wrote to the local authority, I hope then by municipality. Did municipality agree with the public road to be given or to be converted into a plot? Do we have a letter with you that the authority then, that is the Eldoret Municipality, agreed with your request that the access road be changed into a private land? 2, on the same. Did you follow the law that guided or was guiding the process of acquiring a public land, making it a private land? Did you follow? Do you have that law that guides somebody? Because a public, for you to get, you can acquire or you can be converted a public land to be a private land, but there is a process. Do you have the law with you that was supposed to have guided that process? And if you have it, can you share with that? And did you follow it to the letter? And finally, after answering how you acquired or how you are allocated the lower plots that are not standard, according to our eyes, they are also not standard because they were open space. That is plot number 459 and the other 2 plots that are there. Whatever you are calling that you surrendered, though the question, my first question was, whatever you surrendered, was it meant to be FIM's land? Whatever you surrendered, today, is it being in use? Because when you surrender a parcel of land to be used as an access road, like whatever was closed, is that land being used today as an access road? Because that was the agreement as per your letter. Today, if you go on the ground, can we find that what you are calling that you surrendered, is it being used for public use as a road? I think by now, I leave there, Chair. There are a number of questions. I hope that they have written down, and if they would like me to go back, I am in a position to. Thank you.
Thank you, Honorable Muya. I would direct that we allow them as well to respond on that specific question. And I think the simple question is this. The so-called portion number 435 was surrendered by your client so that they can now be allocated block number 6441. But in our records, what document do you have to show that you are the owners of plot number 445 so that now you can say it's available for exchanging with block 441? I think that is the question. It's an public knowledge that that was a public space, not available for individual. Kindly, sir.
Thank you for that question. First of all, I was not there when Honorable Muya was young. I was not there when that space was open space, as he alleges, which is also not evidence by any document that it was an open space. Anyway, what I want in direct response to that question.
Point of order. Kindly, can our research office help the chair to make him understand, because he does not know that it was an open space, for him to get to know, so that, because if we read from the same script, we can now move forward together.
I think that is in order. Royce, can you show the council how it used to be before?
Pursuant to your invitation, Chair, you called us to answer questions regarding plot number 460. Even nowhere in your letter talks about any other issue regarding that letter. The letter is narrowed down to plot number 460. And we are saying, yes, if you ask certain questions like when it was an open plot, I might not be in the purview of answering that question for now. Unless you are saying, Chair, you're giving us time to come and you give us other sample of questions which the committee should hear from us, and we will come and give us all that information.
Thank you.
So unless you are saying get away or stretch yourself from what is in that letter and answer further questions not related to what you called us to answer, then you might have also to give us time.
Thank you so much, Council. We know you are applying now your professional knowledge to not to allow this committee to go further. I think we are all here for the good of all of us. We have no malice in any way, and that's why I say any other documented evidence, even in your own oral submission, it still can be admitted by this committee. So when you become technical, but now let me ask you this question. Sorry, will you mind if this committee will just share with you what we have in our possession, because you say it very well in your statement that because you don't have any evidence to show the previous history of the area, but you said, yes, you might not have, and it's not a must that you must be having, but you said, we are privileged as a committee to have that history. And remember, sir, we have engaged other authorities over this matter before, and they have given us some of the documentary evidence. So will you mind if we share with you? And some are certified, in fact, by the Survey of Kenya. If you don't mind, why don't we share with you? Or do you have reservation for us sharing with you what we have?
With your kind permission, Chair, that would amount to an ambush for us because we were not prepared to come and see documents from the committee. We were prepared to give information of what we have. And if indeed we have to look at that document, then it then means that we should have come here prepared to answer questions related to some documents which were going to be given. Because according to the letter you said, bring documents related to parcel number 460, and we have actually to our best tried to satisfy the committee of what was needed from them. So I don't think it will be fair for the committee to ambush us with a document alleged to be a PDP or RIM, which we are not prepared, because we'll not have an answers to that anyway.
Thank you.
Yes. Point of order, Chair.
What is out of order?
Chair, the council, this is an inquiry house. We don't have to serve you with every document that you may wish to rely upon. Maybe the manager is here. He should be in a position to answer things as we put it correctly before him. We are inquiring a matter that is in the public domain, a matter that has public interest at the core. So maybe we put the manager because he was there at that time, and he could well be prepared to answer those questions that we ask.
Before they go, you give the mic to them, Chair. Yes, I like how the council. I hope both me and him, or either I came earlier than him, from the look of everything. But in the world that we are living, we say information is power. Yes, he might not be conversant with those, but maybe after seeing the map, we are not saying that we are going to crucify. No, we are just a house of inquiry. We are not saying that films are guilty. No, we are just inquiring after a public outcry. And I think the legal counsel, being a learned person, I will not call myself friend because they call themselves learned friend who are in that category, but I think it is for his own good to know. It's not for you to use the information, but just to see. Because when you'll go out of this house, there are things that are going to crisscross your mind. What did I saw? What did I saw? What was the committee? What did the committee show me? And what is my client telling me? So that you can give a good opinion, so that we can help the owner of the land, the public, because we don't want to fight. We are not here with an intention of fighting. Not at all. Would like, as leader, we have a generation to come. Would like to do what is best for us, what is good for us now and even future. Therefore, Chair, how I wish the legal counsel would have just seen, so that he can also compare with what he has. Please.
Thank you so much. Now, back to you, counsel and your team and your manager. Whoever.
Okay.
Your discretion.
Thank you. Because I think member wanted to get a clarification from the manager himself. I think I will not go outside what the council has said. Here there is a letter which is clearly stated, a letter dated 2nd February 006 from the Minister of Lands for the Commissioner of Lands. This one,
Mr. Osoro,
yes.
Do you have a copy of that letter?
It has. You have the original with you. Yeah, I'm just saying about the original, which is dated on 2nd February 2006.
Yes.
And the council has already submitted something about it. It's only my ample submission now, and maybe to answer the question from Mheshimiwa. When we are dwelling on these other questions that we wanted a clarification, this letter here is self-explanatory, and it is from the lands itself. And furthermore, this thing has given us all the facts and what transpired to have this land called 460 legally acquired. Anything outside of that, I don't see whether there is any good reason to give this letter, which is an authority written by the government agent. The government has never disowned this person who wrote this letter, communicated to us, and gave us the authority maybe to have this. Another explanation will not make any sense, because there is evidence you wanted to know whether we legally acquired this parcel. And we have brought all this document to, instead of talking, to just prove to you through this document that this land was legally acquired. When we go to historical facts, as Mheshimiwa Muya has said, I think I'm older than Mheshimiwa Muya, and I've been here for a very long time. I've been a manager of that place for the last 35 years. I've been working with films for 35 years. And Mheshimiwa is aware about it. That anything that has been done, I've been following this. This is why we were able to go back and trace these documents. In normal circumstances, when you are keeping files, when you are storing records, there is a period with which you are supposed to keep these records, and after that, you destroy them. And if they are records, records of historical facts that can somehow be produced legally somewhere at some stage, then they are supposed to be taken to an archive. But we have been able to put a lot of effort to get these documents.
Thank you.
When some of us were still very young. But 35 years in that particular place, I think I know what was there and what is currently there. And what we wanted to show here is how we acquired this, and we have brought all those documents. So another question again, relating or going outside this, I think it is not going to help us.
Thank you. Now, I'm a bit, you're complicating this matter further. When you say it's not going to be of any help, I want to say, indeed, it will be of help. It's only that we didn't mention during our invitation that you come with maybe FR maps for that area, maybe for 1995, 6, 7, 8. But if that is going to be the basis of running away from the submission, we might adjourn and then we give you another further date so that we give now, we request all these documents. But nonetheless, yes, you are older than most of us. I know you, you know me. But probably should be the most resourceful person to tell us now, let's say outside whatever we're discussing, just for general information. You know, some of these engagement is a learning process. Are you not in a position to tell us what was it before? I can tell you such area, it was a forest land, it was a playing ground, you see? So I want to give you are you able to tell us maybe a brief history of what you used to know about that surrounding area?
You know what I know, Chair?
Yes, sir.
And honorable members. Even Eldoret was just a forest. Nobody occupied this place. They came to develop it when these white people came. So any other place has been just vacant, like what you are talking about. When we are talking about a few years ago, looking at this Uganda road, beyond Paradise, and there is a place we used to call Tugera. That other place was a forest. looking at this other side to the hospital, this was just a forest. They came to develop it much later. So if we go by that history, we need the chair, we need what? We need documents like this that we have given.
Okay,
and I
thank you so
thought
much.
it could be good for us to go and get these documents, which our council has just read for you from the Commission of Lands. And it so happens that it is the same farm that used to transact on this. It was the farm of Kimaru Kiplagat, where one of the directors of the now Chariot was also a young person there, a young lawyer, and he has the history of this. So whatever has been given here, as council said, we have got to look at the specifics. I mean, that is, you call us to answer on how 460 was acquired. We have been able to talk about it and again submit a document by a government agent who the government has not even disowned today, that he was not acting on behalf of the government.
I think nobody has disputed the officers then. The only concern was this. In your own submission, and even in this letter, parcel number 435 belonged to the FIMS. And that was the parcel of land that was exchanged for plot number 441 to be amalgamated with, was it plot number 8 or 9? Something of that.
Sorry.
Now, do you have any document to show that you really want parcel number 435 then, before surrendering? Do you have any document to prove that parcel number 435 was indeed yours before surrendering now or
Now,
exchanging?
Ed, you told us that we are dealing with 435 and these other things, then definitely we could have gone and see, even we could have gone to the Ministry of Lands again. And then the surveyor is there, Surveyor of Kenya. Then give you the answer that you want through documentary proof. Because verbally, it will not, it won't help me and you when we beat the bush.
We've gotten you.
For example, yeah, I think council you will answer on that on my behalf, maybe. Then you give them the 435, which is there.
Sorry, trickling down from the question that you've asked, I just want to clarify something that you've just said, Chair. You talked about that the parcel of land 435 was exchanged. It is not the entire 435. It is a portion of 435. Yes. So when this portion of 435 was subdivided, the new number that came was 459.
Who was the owner of
Who of the, yes.
parcel number 435?
FIMS.
And when was it allocated to them?
Farm Implements Limited.
Do you have a list?
Yes, I do have, in fact, the leasee, according to the description in the title, is Farm Implements Limited. And it was allocated in the year 1997, when Honorable Moya was young.
Chair, through you, I'd like to seek your indulgence, but Council, matters land deals also with law. We have been contemplating throughout this inquiry on whether a public road has a number. Yeah, whether a public road has a number. So it was, oh, you are still continuing to answer? Okay, okay.
Now, members. Are you still...
And when he answered that, Chair, we agree, you have the lease. And I was young, 1997. I totally, everybody has his history. The pertinent question here is, according to the PDF, and the director could have guided us, but he has evaded, which is his own right, on how that parcel of land looked like. And our argument is, whatever you are calling 435 and other 3 parcel of land, initially it was an open space before even FIMS gotten the lease and whatever. And being an open land, it was a public land. And for you to acquire a public land, there is a process. There is a process guided by law. And because we are a house of investigation, we wanted to know, was the law followed to a point that now a public land changed from being a public land and it became to individual plots? We wanted just to hear. But we know that you are evading, that you are not called here to give that information. And the chair will guide on that. And we are not in dispute that 435, part of it was hived to in exchange of whatever. But that is the history, because that was the chronology of event. How did the open space, being a public land, change into a private land? Was the law followed to the latter? Because if today the managing director stick to the letter, to stick to the document, I would want just, I'm not a learned friend, but I'm a leader. I'll just invite them to see what is happening today in a land of the late Gerishon Girema and the Mavoko. Is it Mavoko? I am sure those people have the so-called letters and papers which were accent by government officers. Therefore, when we are sticking to these, we know we are living in Kenya. We know what happens in our country. And we are not saying that the managing director is guilty or is part and parcel or whatever. There is somebody who sat and given that. But the question is, was it done following the due diligence? And that's what the chair is just asking. Thank you.
Council, please.
Thank you. Just a point of clarification. We came here to answer all the questions. We are not evading. Additionally, my client has not evaded. He is sick. Just is unwell. So, as you have said, as you have asked that question about, you are saying that parcel of land and other parcels which were there were open spaces. And probably, most parts of this town were open places that time. And probably even this county assembly was an open space that time. So, unless you are saying there's somebody complaining that this land was allocated to someone else instead of myself, because we want to know is the complaint, because now the legality and the legal procedures, the legality of acquiring the same is not in dispute, the legality and the processes. Unless you are telling us there is a step that was kept in processing that leases, because according to the documents, and we also have, we have shared the copies of titles, of which we have explained why we don't have the originals, is because when you apply for, when you apply for an allotment of land, then the only procedure or the only person whom gives allotments was the Commission of Lands. The correspondence we have shared were between the council for FIMS and the Commission of Lands. Unless you are telling us that the county council, there's also a procedure where you get the approval from the county council, of which it has not been the provisions as to the requirement of obtaining, because the law as per that time is whenever you want an allocation, you apply to the Commission of Lands. And the Commission of Lands will consider your application and give you an approval to that effect.
On that?
What is out of order?
Thank you. Not out of order. I want it to come out clear. Whenever you have said that it was you were to apply, do you have the law that was guiding the same? So that we don't want to victimize anybody. Do you have, because you are saying the procedure was to apply to the Commission of Land. Do you have, as a legal practitioner or person, do you have the law that was guiding then, so that as a committee, it will also guide us? Do you have, instead of just saying it was a process, you are supposed to apply to the Commission of Land? Do you have that law? Because we don't want to victimize anybody. It will guide us. And we are going to visit that the law was A, B, C, D. Do you have it?
And as I said, this engagement is also learning. We are also learning some of the things. So, for our own good and also for future. So assist the council to understand that.
Okay, to clarify, I think the law as per that time was in accordance to the RTA, which has already been repealed, and the current law, that is the Land Act and the Land Registration Act, which came in force in 2012, are the ones which are guiding us. The law as per that time were repealed, and if you tell me to quote the exact sections of the law, then I cannot for now. I think
Chair,
Honorable
at
Muya
that
has
point-
made so many objections, and I have not answered any of his questions. I have never answered any of his questions. I don't know when I will answer them. I think it will skip my mind. So you talked also about the issue of how and when can a public land be allocated or be have numbers. Yes, and I will answer this way. When a public utility has been earmarked for allocation or for alienation, to say, so to speak, then what happens, the Commission of Lands will have it, the Director of Survey, you apply to the Director of Survey in the Commission of Lands in conjunction with the survey, Director of Survey, will actually have it allocated a number. Because you cannot just, all these roads that we have, they don't have numbers. They don't have numbers. So what happens if you want to acquire, it is allocated a number. This, for this case, it was allocated number 441. Then once the number is allocated, then now you also hive off or you subdivide the subject parcel which is to be exchanged with. 435 was subdivided for that effect. So the number that you are saying, at what point is public land allocated number or as a number? It was allocated for purposes of the exchange.
At that point, I'm not disputing. I'm not disputing here. And he's coming very well. All public roads does not have a number. And that's what we know as laymen. And I asked when it was allocated. And you say at that point is the Commissioner of Land who allocates. We'll only clear that if you furnish us with the law that also support his action. And now we are going to ask that the legal person who represented FIMS did even submit it to the committee that the commissioner was guided by this law. We are a house of inquiry. Kindly, if you can give that law that the commissioner used, will come out of that area. Do we have that law with you, whether repealed or in existence? Do we have?
Normally, he who alleges must prove. If you are alleging a certain law was breached, which to the best of your knowledge, you think it should have not been done, or it should have been done otherwise, then you should be able to tell us you did not follow this law in processing those documents.
Can I buttress that?
Because now, if you tell me quote the exact sections of the repeal law that was repealed over 13 years ago, you should have prepared me to come and tell you today or any other, because I cannot. Even you, if you ask certain Okay, I'll ask you some provisions of this house that guides this house, and you'll tell me the section. If you are able, then I must answer the same way. I must correspond. Okay.
Chair, this is to you.
Chair,
will you wish to ask him? No, order, Honorable Muya. I want to give Honorable Wanjoi.
On the same, so that maybe I clear this question, because I had it as my question, and I'd like the council to repeat the same question. I want to practice, but that one question. A road is it's a public utility, distinct from other public utilities such as hospital and primary school or whatsoever. This is a straight question, council. Can a road be open? Can a road be open to be amalgamated by a private entity? And if yes, what are the conditions that are applied for a road to be taken by a private entity?
Okay. Council.
Okay, in
alleges must be ready to prove. You know, we are learning. And what I want to say is that he's open, he's bringing an eye-opener to this committee, that before we write our report, we should do a research through our legal researcher, because the commissioner must have been guided by a law, which the legal person does not have. We might not have, but that's a question that when we are retiring to do our report writing, we must have that law that guided.
Noted, Honorable Muya. Yes, and remember,
he has not finished your questions.
Honorable Naomi Serem, and then you will answer together with Honorable Wanjoi's question.
Yes, to add up on what Honorable Wanjoi has stated, Chair, if you amalgamate the road, what stops your client from amalgamating the next road and any other public land? My second question is, why did your client stop the constructions after 206, after the members of the public demolishing the construction that was going on? My third question is this: in case and there is an emergency, where will be the alternative road for maybe the fire extinguishers to come to the site? Thank you.
I think you can answer those questions.
Thank you. Honorable Muya, Honorable Wanjoi.
Through the chair.
Through the chair.
Yes.
Chair. Thank you for your guidance. So, what are the conditions for, that is your question, protocols to be observed in acquiring a road or a public utility? I'll go back to what I had said initially. First of all, you apply to the Commissioner of Lands for the Commissioner of Lands to consider whether it is viable or it is, because the resource that was advanced by my client at that particular time was because of a vandalism, stealing, and even two is that road cuts across is 2 parcels of land. And so it is upon the discretion of the Commission of Lands to decide, after considering factors that guides them, to decide what would be the implications of allowing the amalgamation of that road. Because our client said that, yes, let me acquire this road and then cut my parcel of land at the far end and I another road. So it would not serve any, it would not, at that particular time, it would not actually affect the interest of the public because the road was going to be sufficed. So the reasons were beyond our client's sustenance in that place. And that is why it was the commissioner who decided or who actually had the prerogative of deciding whether to approve or not. So it is not within the confines of our clients. Our clients only applies, and any other person can apply if you think that area is not comfortable for your business or not comfortable for running any daily activities. But the peculiar reasons of that parcel of land is because it was cutting across two parcels of, and that is, I believe, it is the reason the Commission of Lands thought it would not affect the public.
There's a question that you jumped. I asked two questions in one, Chair. The first one was, can a road be taken over by a private citizen? You know, as I said, a road is very distinct from any other public utility, such as hospital. Yes, it's one of public utility, but it is treated as special because of its access to various building and what have you. My question was, can it be taken over? Can it be amalgamated? There was a person here, an officer, that hold a contrary view as to your presentation today. That's why we clearly want to know on this issue if a road actually can be taken over by a private citizen.
Okay, in response to that, it was not a taking over, it was an exchange. It was an exchange. That portion of land, it was an exchange because our client surrendered a portion behind and then took over this one. It was not taken over, it was an exchange.
In amalgamation, it's being taken over. Whatsoever you want to say, if it's exchange, let it be, but it's being taken over by a private citizen. Tell us if it's yes, just or a no. It's straight clear.
Legal counsel, now, sometimes there is a point that sometimes we put our education and our professionalism down. Yes, you want to say that this service lane was serving that parcel of land. But all service lane have a purpose. There are other parcel of land along that service lane. In case today we have fire, or so to speak, and God forbid, those are the areas where we want maybe even to do garbage collection and the like. It is this service lane that is being used for the said purpose. Leave alone maybe defending the client, because he saw the need of this service because of one dimension. But we want to have the big picture. And I want to remind the legal council that we are transiting into a city, from a town to a city, where every access road, where every service lane will matter for the good service of the citizen of this great county. So when you're arguing, kindly let us have this big picture of why are we arguing all this. Because when we have planners planning a given town, giving access road, giving plot numbers, they have a reason. And that's why they went to school. They did not go to school to be lawyers. They went to be planners. They planned that areas to be the way it looked like. And finally, when you are applying to the Commissioner of Land, there were other users of the said access, whether they were not properly using it. But we had a council in place, Eldoret Municipal Council, who ordinarily was supposed to have made that road be accessible, not being a den of robbers, not being a toilet. Therefore, apart from applying from the Commissioner of Land, without a law or with a law, they ought to have also applied to the relevant authority. By then it was Eldoret Municipal Council. I hope the owner, that is FIMS, applied to the relevant council, that is Eldoret Municipal Council. Do we have such a letter? And what did they reply to FIMS that you want to use that, or you directly applied to the commissioner? Did you also apply to the local authority, that is Eldoret Municipal Council, and what was the answer?
Thank you. I think you can proceed to respond or answer the questions that has been posed. Proceed, Council.
Thank you. I think what Mr. Moya is asking me, in other words, is asking me if is actually telling the committee that the procedures that our client used to get the approvals were not the legal procedures. And because he asked me the provisions that allowed the commissioner that the provisions that would allow the commissioner to approve. I think because he has posed that question, he can also tell me the provisions that says that an approval cannot be complete or cannot be legally correct unless there is a municipal council approval. Because now, what we are saying is that the municipality has never objected to the acquisition of that parcel of land from 2006. It has never objected to the same until the day we are in now.
Did the owner notify the authority?
So
that's the simple
what
question.
We are saying is, what we are saying
through the
is,
chair, point of order.
the commissioner.
Honorable Moya, allow him to conclude and then just note that point. Yeah, proceed.
What we are saying is the protocols were followed to the letter. The commissioner of lands was the sole person to approve all amalgamations, alienations, and even new allocations. So telling me or telling us that, or telling this committee that there was a municipality or the committee in the municipality who were also supposed to be informed, we were not aware of that time. Unless you tell us there are provisions which we would have actually followed. But as at that time, the Commissioner of Lands was the only person who allocates new parcels. He was the one who was supposed to,
in simple terms,
approve allocations.
In simple terms. He's finishing, but
okay,
I've gotten
maybe
him.
I will allow you just ask
what
the
I'm
question.
saying, he just confirmed that whether there was a council or not a council, they just sought the permission from the Commission of Land. They did not bother to notify the custodian of that service land then. That is the Eldoret Municipal Council. They did not, because if they notify, there is a letter that when we were doing it to the Commission of Land, who ordinarily is the one to allocate, alienate, but because there were authority who are supposed to have maintained that service land, we even gave this protest letter that you have neglected this and therefore we are doing. They did not. Do they have such a letter? Because the council was not the one to allocate or alienate, but they had an uploaded letter to the council and they answer? Only that.
Council, please.
As far as I'm concerned, the Commissioner of Lands was the correct person to apply for any allocations. That is my simple question. Any amalgamation.
I don't need another answer. They overlooked the then municipal council. That's what is coming out clear.
Okay,
Nothing was overlooked. I'm answering, I'm saying, at that time, there was no requirement to get approval as at that time. The approval you'd get from the Commissioner of Lands.
Order, Honorable Moya,
Yes.
kindly.
Yes.
Please. So I think he has answered. Yes. And I want to say that maybe we need to take note of that certain provisions in the law then, so that, you know, You've tried. You've tried to convince us, and it's in order. Now, I don't remember. Do you have another question before I pose another question? Maybe in relation to this matter. Just refresh again, please.
Honorable Moya has been making so much objections, and then I lose track of the questions that I'm supposed to answer. There was also a question that asked by Honorable Naomi. She asked me why didn't the committee amalgamate or acquire the next plot. And the answer to that is that the reason why they were doing the amalgamation is that, one, our clients saw a problem. Their problem was vandalism, and it was between those two lanes. And he saw a solution. And the solution was to apply to the commissioner to forfeit this portion constituting a lane and give the government the other portion. There was no point of amalgamating other parcels of land because there was no need at that time. The need that arose at that time was vandalism, stealing, and burglary. So there was no need of amalgamating other parcels of land. Yeah, another question was whether the law was followed in getting the amalgamation, and it is outright. That one is clear beyond Baradfenja, that we have given the procedures and the correspondences between the Commissioner of Lands, our client, until the point of approval and issuance of leases. There was no single law that was breached at that particular time. All the protocols, all the law was followed to the latter. Thank you.
Chair. Honorable Andrew, you've just come from outside. I think a lot has taken place while you were...
I know. It's not a point of order. Yes. I had my questions. The other one was...
will you allow me to allow him conclude what he was answering?
Okay.
So that if there's a question that he forgot, I will give you opportunity to refresh it again. Proceed, Council.
The question was the law followed in actually alienation of 441 that was initially a service lane? And my answer was, as per the documents that we have submitted today, the correspondences between the Commissioner and it is clear beyond adventure that there was an application. I said my client saw a problem, and the problem was with vandalism, and my client also saw a solution to that problem, and the solution was to apply to the Commission of Lands, and the Commission of Lands found no problem in exchanging that portion or that parcel of land with the next parcel of land, and he approved, person to which my client took over the parcel. He was given the RIM was amended, and he was issued with leases and certificates of that, and he has occupied that parcel from that time until the date of the allegations that gave rise to this meeting today. Thank you.
Are you done, Council? Now, Honorable Wanjoy, please proceed to ask or refresh the
Chair,
question.
please note that the one I was addressing Muya's question, in which was not answered, and we'll take note of that, and we'll do our own research on that. We do not have to ask a question, then repeat again the same question. Let me ask mine now. Council, do you have, or even the manager, was there any public participation done by when that plot was being amalgamated? And number two, also on public participation, did you carry any public participation recently before actually building on that plot? Number two, and if yes, please tell us which form of public participation that you carried. If no, just leave it. Number two, you base insecurity as one of the factors that led you to now apply for that plot to be amalgamated. We take note that ever since you applied for that until now, the plot has been an access road all through. Then, which basically tells us, yes, your motive will have been to keep away the insecurity menace in that area. But again, there was nothing that was constructed on that access road. It was still the same until recently, when now you started constructing there. What made you all along, if actually you felt that insecurity was one of the things that made you to apply for that amalgamation, then why didn't you construct until now? Number three is that I'm seeing by February, because this letter is dated February, by February, 2nd February 2006, you wrote a letter to the, I think, Commission of Lands, which means you had not been given that area of land. There was a protest letter by Juakali Association that was written on January 2006. The contents of the letter was that you actually closed that road. It was 19th of January 2006 that you closed that road on that night. And the office is addressed to the town clerk, Eldoret Municipal Council, way before even you were allocated that parcel of land. And then after this letter, the Juakali Association and the people around there did manage to actually bring the wall down, which means that you were even constructing even before you were allocated that piece of land. What would you have even to say on that? Because your letter clearly shows when even you applied that land to be amalgamated. That one, by that, Chair, let him answer.
Okay, kindly, Council, you can proceed to answer.
Thank you. I'll give the manager to answer the questions. At the same time, Honorable Wanjoy is saying that this road has been a way through. That is what he's saying. At the same time, he's saying in 2006 it was closed. You see, Honorable Wanjoy, you cannot have your cake and eat it at the same time. I don't know what you mean in that.
There was an attempt to close that road 2006 before January, and then the resident of that, not even the resident, the business people around that area did a protest letter to the town clerk, and they managed to bring that wall down, either forcefully or through a protest. They brought that area down. It was an attempt to close that area of land, which means that you even wanted to construct even before you got that amalgamation.
Council, proceed.
Thank you. I'll give the manager to answer that question as to whether the road is a way through and whether it was closed. But as much as let me give him to answer that question, and then I tackle the rest.
Yeah. I could like to be straightforward on this. The answer is that we have never done that, and if we did it, it has never been brought to our attention in 2006. There's a time we wanted to do it, and actually we put up some balls,
Do you,
which was
do you
still
remember
there.
that time?
When? It is
That you're saying there was, you said yourself there was a time that you did it?
Oh no, we didn't do it. It
Yes.
is later on when we wanted to do the construction which is there.
Okay.
Yes, but it has been left like that, and we didn't have the finances to do it. If you don't have the finances, so long as that you have acquired the parcel, this thing was to be put up after the finances were available. And maybe, Chair, when you are asked a question, whoever is asked a question, it is like in end research. When you are taking your questionnaires to respondents, you don't expect them to answer the way you want. You should approach this issue with an open mind, not a closed mind that you want a particular answer. What we are saying is, for example, you are telling me why you are asking me, maybe, did you follow the due process? This thing is here, through the lands. Now the other question, have you ever attempted to close this road? The answer is no. Why did you leave this place after approval for a long time? We didn't have the finances.
Chair, please.
Yes,
let the respondent know this, that you're not going to tell us on how to ask you, in which form to ask you. This is an inquiry house, sir. And then number two, we are following the words of witnesses who are here before you. And they have even stamp letters they came with stamp letters with them, showing that you attempted to close that road at night, 206 January. So we are not just asking question out of our way.
Through here, that's what I've answered.
Wanjoy, are you
because I didn't have any information about what he's talking about. We were not notified about it. And if you were served, you did not even inform us about it. And what action was taken? If they did that, what action was taken? There was no action taken because we have never attempted to do anything on that particular plot. And this is what I'm trying to say. I'm not directing you how to answer it. If you are conducting a research, it is because you have a problem. Like now there is a problem, this is why you need an answer. If you are looking for an answer, you go to the people who can give you the answer to that problem, who are the respondents. And for this matter, we are the respondents here. Whatever we give is what we have. And if there is anything contrary to that, then maybe you could give us that letter that you served us, that we have seen here, you are blocking this road. Why did you block it? If you have that evidence through that letter, then we could be able to answer that question. But the allegation that we attempted to do that, and what action was taken, we were not asking, we were not informed about it. Or maybe if it was the municipal council, they did not even come to us. We are not aware about the allocation you are talking about.
Wanjoy, are you satisfied?
Yes, we take all the answer by the seriousness it deserves, and by that they are saying they haven't attempted, and we have records to the contrary. That is left to the committee to decide at the report writing.
Okay.
In addition to that, Chair, how are we that the anger that I'm seeing coming out could not have come, because we are a house of inquiry. However, how many questions I ask, for example, the learned legal person knows that even when we follow the proceeding in the court of law, sometimes the other side might feel irritated, but that is immaterial. Therefore, how I wish that we could have controlled ourselves, even if we could have asked.
What is your question?
My question is, my concern is, the representatives of the SIM, the owner of FIMS building, how I wish they could have calmed themselves, answer as much as possible, and what they can't answer, they say, on those one, we wish be given more time to. That could have, because we are not here to victimize them. We are not here.
Okay. I think
that is the issue.
You've passed the message.
Chair, in fact, when you are charging people before you hear them, this could seem the honorable members have already thrown their judgment before they have heard from us. This is what I'm saying. When I'm answering a question, I'm not being emotional, because I cannot be controlled by emotion. I'm only trying to answer your question in the way I can. I'm not a person with high tempers. It is the way I talk. I'm a lecturer of a university. I've repeated that again. I have my students. That is the way I talk. There are people who talk, you think they are talking authoritatively, but that is their nature. And you cannot judge nature by that way. Jaya?
Honorable Muya, are you satisfied with that? I hope so. But I will not give you order, Honorable Muya. I want to give the council to proceed on, but let's do away with that kind of debate.
Thank you. Honorable Muya is also saying that I should not be here, but my client should have been there personally. They are guaranteed of that right under the Constitution. What you are essentially saying is that he should not have been there.
That is not my point. I have not objected his presence here. What I said is that when they are representing the owner of the land, they answer as much as they can. What they are not able to answer, they can sort maybe extension of time. But I did not say that they are here.
Remember, we are dealing with a learned council.
Okay.
He knows how
I
best
stand
he can deal
guided
with matter.
here.
So,
thank you.
Where was you? And there is a reason why he has chosen to take that approach. Council, please.
We will answer as much as we are able to answer. So maybe without much ado, we have questions that have been asked by Honorable Anjoy. My colleague has answered one of the questions. The other one was, I don't know whether he's answered whether there was a public participation while I was outside. So by that time...
That one has not been answered, so you
yes,
can tackle that.
Yes. By that time, that the issue of public participation was not a requirement at that particular time. So there was no public participation and it was not required. The issue of public participation arose maybe in the current dispensation, but at that time there was no requirement of public participation. Okay, and then the other one was...
Chair, on the same
order. Just
there were two in one. It was, did you carry public participation then, and before you started constructing recently?
But I want to answer.
Yeah.
Yes. Yes.
Proceed.
My answer to that, Honorable Anjoy, is that there are requirements or there are protocols that you follow before you erect a structure currently in Kenya. We have approvals. All the approvals that were required to be obtained have been shared. Looking at the attachments in my letter, there was physical planning approvals, there was NEMA approval, there was environmental impact assessment that was obtained, and there was also NCA approvals. So all the approvals were obtained, unless whoever feels that there was a protocol that was skipped, then maybe they can give us information as to that. But as much as we are aware, all the approvals were obtained. There was a building plan. There was architect's approvals, and all the necessary approvals were obtained. So I just want, in answer to that question, all the approvals were obtained as per the law.
Chair, there's a difference between approval and a public participation. I ask about, did you carry any public participation recently? Not approvals. Was there any kind of public participation recently?
Maybe Wanjoy.
There is no, Mr. Wanjoy, there is no requirement
just
for
say
public
yes or no.
participation.
We are not into a contest.
Order.
Yes, and I'm answering. You cannot impose
Wanjoy.
questions on
Kindly.
me. I answer what I have, the information
Say
that I have.
yes or no, council.
No, I cannot answer like that.
Order, Wanjoy.
What I'm saying
Order,
is,
Wanjoy.
Chair,
whatever
asking
is
his
in the
own
public
question.
domain.
He's
Order.
asking his own question,
Order.
Chair.
Order.
I'm asking about
Order.
public participation. The
Honorable
guy is about
Wanjoy.
approvals. There's difference
Honorable
between approval and
Wanjoy.
a public participation.
Tell me where you are required to give public
Honorable
participation in constructing
Wanjoy.
a building.
Are
Order.
you going to
Do you
answer a
have that
question or
requirement?
not?
Order, Honorable Wanjoy. I think you understand.
So anyway,
the
I will
rules-
not answer that.
The rules of this house. Honorable Wanjoy, I expect you to, when I say order, you know what to do. So if I will give you now the floor, you exchange with him, you might not cough. I want
Point
to
of
request
order,
this.
Chair.
Let's
Point of order,
order,
Chair.
Honorable Muya. Kindly allow me to
Point of
say
order,
this.
Chair.
Honorable Wanjoy, just relax. Whatever the manner that he wishes to answer, let's allow him. Even if answering while crying, let's allow him. Let us not question the way he's answering. It is the reservation for them. Kindly. Do you have any problem with the way they are answering?
Chair, let me
Do you-
reverse this.
Is there any standard? No. Order.
Maybe you don't get me. Chair,
now?
allow me to say this.
Order, Honorable Wanjoy. Kindly, why don't you just respect the chair? I've said, in whatever manner that they will choose to answer, whether while crying, laughing, explaining, keeping, shutting their mouth, it is their right. Unless you have a standard form of answering, let's give them discretion. Even to keep quiet is a way of answering.
Chair, I haven't objected to the way they're answering the question. What they're doing is they're asking their own question from them. I'm asking a question, they're diverting that question and answering the question that they want it to be answered. I ask about, was there public participation recently before the construction? It's a yes or a no. I didn't ask about approval.
The problem is this, you are insisting them to say yes or no.
Yes.
If they will answer and explain,
If
I
they
can't
fail to
stop
answer,
them.
just let them say we are failing to answer. But it cannot be that they
Anyway,
ask their own question.
order, Honorable Wanjoy. Kindly, let's calm down so that we can get the information that we want. I think you have heard him, and kindly, and I want to request Wanjoy, specifically you, relax, let them conclude, and then I will give back to you. And any other member who wish to ask questions, kindly cancel, and don't refer to just to conclude that kind of altercation. Don't. Just proceed to answer questions.
Apologies, Chair, and thank you for your guidance, and apologies for the exchange that we've had. It was not it was not planned, but I wish to apologize.
It's okay.
Okay. My answer to that is that there is no requirement for public participation. What actually is normally done in a construction, there is what we call environmental impact assessment. The community are allowed to give their opinions, and then that environmental impact assessment is taken to NEMA and they approve. That is the short answer to that.
Are you satisfied?
Was it done?
Just to answer that, yes.
It was done, and that is why we have a report which we have filed, the EAI impact.
In which form?
There is approval from.
You have an evidence?
Was it a meeting? Or how was it done? Basically, was it a baraza? Was it
Normally, there are forms.
Maybe to answer that.
Normally, let me just.
Can I allow them?
Let me just
counsel
answer.
to.
You know, to answer that is.
Let me
very
just
simple.
You want to answer who?
No, to answer that, whatever that question.
Okay.
Yes.
The legal counsel ought to have said yes, it was done, and these are the evidence that the public was engaged.
And that is why I said, let's give each other time. If there is a way of expounding on the same, we allow you to expound. If there is no, you say yes and stops like that. If there is a justification to that, and I want to request that, if you have any evidence that a public participation was done, kindly submit to the chair. Proceed, Council, to answer.
Thank you. I know Honorable Anjoy and Honorable Muya are quick learners. So they would actually bear with us. We will catch up with them. Okay.
Kindly.
So
anyway, answer what you are able to answer, and the issue of evidence on public participation,
yes,
you can provide that later on.
I'm sharing that. I'm sharing that.
But you are confirming public participation was
yes,
done.
It was done
in relation to the construction.
Yes, it was done, and that is normally done in any construction by sharing flyers which the public have given to give their proposals or their approvals. If they have any objections, they give to the NEMA.
Thank you so much.
And before we get that approval, then the NEMA will have considered that one. So, and we have the approval. That is impact assessment.
Let me ask you.
IEA.
You said correctly that in relation to this matter,
yes,
some flyers were given out. Flyers of informing people that now we are about to construct, be prepared, or flyers in what context? But we can still give you time to seek to look for those evidences. But you said, public participation was done. Are you satisfied, Wanjoy? Now, that is a different question altogether. You said true flyers. I think your answer was symbol. Yes or no? Yes. You said yes. Can we allow him to look for those flyers or any document to that effect? You said flyers, sir. But as a chair, I heard you saying there was a way of doing public participation in a form of giving out flyers.
What happens, normally what happens in a construction?
And if you have anything to that effect, kindly share with us that evidence of public participation, if it is with you. And if it's not with you, I will refer to what Muya said, that you can seek for more time to avail the same. And I still look for other documents. Honorable members, any member with a question? We are about to end our deliberation.
Yes, Chair.
Proceed, Honorable Muya.
This is an open question through the chair. The manager FIMS and the legal representative, having seen this committee how we have raised our question, in most of their part they are saying that the question we are asking is that it's not related to what we ask them to come with. With their own opinion, if given time, because they have seen that being a house of inquiry, our questions are revolving from when they were allocated, all that, meaning that we are interested as a leadership to know all about pertaining, not necessarily 460, the whole land, that is the former FIMS, where even the traders are trading the issue of Magunia, the Juakali sector. Can they be in a position, given time, to give us the chronology of event from when those lands were open lands, how they, all that process, because we do not want to victimize them. They had a right. Maybe it is not their fault. It is somebody's fault. So that their explanation can exonerate them. Are they in a position to? Thank you.
Thank you. And I think, Honorable Muya, they had indicated before that, they were a bit technical. They said as per our invitation, we talked about Block 6, 460. That when we started the issue of block 435. And I want to say, maybe that is something that we need to think about it. And if there is need be, we shall send another invitation over some more information that we might require before we make our determination. I think that would be the best way. But that one, I want to say that it is for us to decide which information can we further seek from them. I think that is in order, honorable members. Yes. So, what do you have to say?
Yes, Chair, there is one thing that I want to clarify.
Yes.
Maybe giving as an example. Somebody might ask you a simple question. When were you born? Do you go back to your ancestors? You will only answer.
Which you were born before you or after you?
Yes, a long time, and say, when were they born? And then when were you born? If you are asked when you were born, you have got to be very specific on that. That is why you cannot ask us a question to give the chronology, just the way it was done up to where we are. You asked us to clarify on plot 460, something that we have done. And again, asking us to go to that, I think the government has got all the record. If you go to land, they have it. You go, wherever you go, there are offices that have that historical events that took place before the present one. You can even get it from the colonial time if you want it. But ours, to be very specific, you don't dwell on irrelevancies. You go to there. Now, excuse me. Sorry. I apologize for that.
Withdraw.
I have withdrawn. What I was saying, and what we have answered, we have done it according to the best of our knowledge. We could not go to look for what we don't have. We have only to answer what we had, and those are the facts that we are. I cannot even call them facts. The facts are stated in these documents.
Thank you, Mr. Osoro.
Yes.
And you are preempting, or in other words, you are trying to tell this committee, even if we will write to you and seek for further information in relation to other issues surrounding that area, it will not be your responsibility to do that.
Chair, that is then. That will be handled according to the way we are getting it.
So suppose we write to you seeking for maybe how you acquired block 435 and maybe tell us or give an evidence to show that that space was open and available for alienation.
We will go back to the records, to the office. That is the record. That
so you will be willing.
The custodian of the records of lands, because they are there, which means you tell us, you write us, we go there, and we will always come back with what they are going to give us. What was there, they will tell us.
Anyway, it seems you backtracked from your initial.
No, now the chair. What I'm trying to say, I'm trying to be to be as clear as possible. If you want to write and request us to give, we will be willing to do it. Because we will go to those offices, ask them to provide us with the records, what was here at that time, even if it is 1909.
Okay, thank you. And I know, let me hope you will not tell us those offices are existing. Go yourselves and seek for those information. But nonetheless, I want to say that we are about to end our session, and I want to give.
Maybe I can serve through the chair. I can serve the legal person so that he can help us. We are not victimizing him. When he go back or retire to go and rethink
now,
this.
Be specific on what do you.
He goes and look for the laws. Yes,
I want.
He asked me.
Are you right? Are you right? If we
whoever
write to them,
alleges,
we write to them on what you want to.
Or we write to them.
Shall write to them.
We shall write to them with the guiding laws that guides the amalgamation, the application for building, whatever, and they are one and the same thing, which start with the amalgamation. There were laws that they were supposed to have followed, and we are going to guide. We are going to write to them, and it is for them to answer to us whether they followed it to the letter.
Okay, thank you. Do you have anything to say before I give you the opportunity to make your final submission or statement? As you answer or give your position on that, you'll also be giving final remarks as well.
Thank you, Chair. Of course, this being a house of inquiry, we will be glad and happy to provide any information that is within the custody of my client that is needed or that would be helpful in determining the ownership details of this property. But whatever you will ask, we will give what we have or what we can get. At that point.
Will you be willing to give us with any information or evidence, even if it is not in the custody of your client, maybe it is in the custody of other agencies or authorities?
Of course, at that particular time, we will try to request for that information. By the time you will be required to be here, whatever will be available, we'll give to the committee.
Your final submission, or you are done?
Okay, I just want to thank this committee. You know, it is my first time appearing in this committee on issues pertaining to land. Yes.
Council, before, sorry, I've requested for the permission from the substantive chair before you do your final remarks. That from your legal perspective, now this one being a matter of public interest, and I know maybe your client is saying that I have all the approvals, I have whatever. Does it concern you that even bothering to say, why don't we hold whatever we are doing, maybe in goodwill, not in bad faith? Yeah, whatever it is going on the ground, pending maybe the outcome of this, or what is your view? What is the view of your client? Or you have that position, you say that we are rightful owners, but it is because of the public, for the good public interest, that even explaining to the public your position can be a responsibility that you can also undertake.
Thank you, Deputy Chair, for those remarks. In answering to that question, the issues that are before us today are issues that arose some days way after the construction of that project. We are also concerned about the investments that our client has put in that property. We are also concerned that the complainant in this matter is the authority or the authorities in the government that gave the approvals. We have not seen a physical person saying her parcel or his parcel of land has been taken. So we believe that if you are telling my client to stop, it is a huge financial loss to my client because he has really invested on property. So at this point, with due respect, Chair, is that we cannot accede or feel that the request to halt the process of construction cannot be a fair thing for our client. It's not going to be fair. Because in any event, in the construction, if the construction continues, the county assembly or the county government is losing nothing. You are not losing anything. It's our client who is losing. So if we say the construction proceeds, if at the end of it all, it is determined that a property was acquired illegally, so the loss will be to my client because the property will be put down. So why does it concern the government to halt the process, yet they are not suffering any loss at the moment? So let the process of, in my view, in my honest view, we proceed with the investigations and the project continues, and then at the end, when we will know who is on the right and who is on the wrong, then at that particular time, a course of action will have been arrived at. So my answer to that is, it will not be fair for my client to stop the construction because of the huge investment that has been put in that project and the intended expected, my client is expecting an income, because it is a loss, because he has got a loan which was approved using the titles, and that loan is accruing interest. And if it is stopped when there is no outcome or there is no illegality that has been put forth at the moment, then it will be unfair. It will really be unfair for the committee to insist on stopping the project.
Yeah, I thought we had finished, but for the record, I would like to say this, that we have received various complaints from the public. I, being the representative coming from that area where actually the land is situated, I have received various letters and calls and what have you about the same plot. My colleague also has received that. That's why it came to this house. We as a house, we cannot start any investigation on our own motion. We have to receive various complaints from the public. Number two, we have still people, Juakali Association, who are here, and they really contest you going on with that kind of activity. So by that, you should know that the greater public is actually suffering if or it's continuing. The greater public continues to suffer by the closure of that road that should go into into their table.
Can I answer to that? Thank you, Deputy. I think if you say, if you at this point preempt yourself and say the public is suffering by the closure of that road, and what is before us is an investigation as to whether the road was acquired illegally or by law. So if that investigation is underway, the public, you cannot say the public is suffering by the continuous construction of that project. It will not suffer anything because the construction is already on course. And we even wondering why this comes at this particular time after construction, because that land has been there for more than 10 years. And we don't have any documented evidence of complaints. So if you say now stop that process, the only person who will be a victim of circumstances will be my client. So whether the people are complaining or not, it will not serve them any right to have the project continued. It will not serve them any right because it's no longer a road at that particular. Okay, thank you.
So thank you, Council. It is not that this committee has given direction that you stop. We were seeking your opinion in the good interest of all of us, because just the way you have just confirmed to us that let it continue. After all, it is not the government that is losing; it is your client who will lose at the end of. It was just an opinion from your side that for prudence. Yeah, so it was just a comment. So you may proceed giving your final remarks to this committee so that we come to the end.
Okay, thank you. I want to thank this committee for listening to us, looking at our documents, and actually assisting us in some of the areas, gray areas that we were not able to clarify completely. And I also want to thank Honorable Anjoy and Honorable Muya. They have been joking our minds and giving us, testing our temperament and our emotions. But at least we were able to arrive at least we were able to conclude this meeting. I just want to thank the entire committee and the chairman and the deputy and the leaders of this committee.
What is that a point of order?
Yes, yes.
Okay.
Yes, please. Because I'm in agreement with what the legal representative is saying, but before we leave, because they're giving their final submission, here there are very important things that we'd like to get from the client himself. That if we can get the plan registration number, the date of submission, if we can get those, it will help us in our...
I think we can write a letter to them.
Okay, thank you.
Requesting all those documents.
Thank you, thank you. Thank you. Then he can proceed.
And again, I'd say it, maybe before you leave, which plan is that? Construction plan, is that what you meant?
Yeah, that's what I meant. And if they can be honest with them, was this the first time they submitted for it to be passed, or they tried submitting the same in the previous government? Because, you know, offices are perpetual, but the office bearer.
So you are talking of architectural approvals there. Anyway, the question is this. Was this your first time to submit an application, or you had done it in the previous years? Am I putting it
You're very right.
MD, I think this is your question, eh? Have you, did you, maybe the point is this. Was this your first time to submit an application to the county government seeking approval to construct that area, or you had made it maybe other years back, maybe with Municipal Council of Eldoret, the first county government, the second, and perhaps the third? Kindly.
Yeah, I will have an answer, just a simple answer. No, I don't know. That one I don't know.
Even you don't know that you submitted this one,
no, this one
in
I
last
know.
year?
This one I know. But
the
other one?
No. MD,
what I was trying to say...
I'm almost concurring with my colleagues.
Chair, what I'm trying to say is this. You have asked me a genuine question, and I'm giving a genuine answer.
Yeah. Anyway, let's head on that, and thank you so much for your presentation. And should we go further, we shall elicit some questions. Otherwise, on behalf of the committee, Joint Committee of Lands, Physical Planning and Housing and Urban Development, I want to sincerely thank everyone, from honorable members of our secretariat, from FIMS, the council. Thank you so much for taking us through the deliberation. We've noted and we have learned, and just want to say we are doing it in honest, with open mind, and in a situation whereby you might have, we might jointly engage in a manner that it didn't go well. We want to apologize, and therefore, whatever you have given us, we are going to look into it as we proceed to make our determination. And as you have heard, or even as you know, Council, that sometimes information given out can lead to further information. So we are not saying this is the end of our deliberation over this matter. And you've said very well, you'll be glad if you will be called once more in relation to this matter, or a matter related to this. It's not specifically this, but even any other matter related to this, you will be glad to appear. So I want to thank everyone, and maybe first you need to make sure that you have all your documents. There is another copy here. Make sure you have your original documents. And I don't know whether you have any other document that you wish us to have as we go and make our further step. If there is anything that you would wish us to remain with, to assist us, we shall be very glad to have it. And Now, in this letter that we gave you, there is item number F in the letter that was sent to yourselves. Can you give them to check on the specific item? So, on those items, order cancel and empty. On those documents, we are not saying we are going to use it now. We have our secretariat. You'll tell him what you have, what you're going to provide later, and then we shall have it for this deliberation. Otherwise, I want to believe you have all your documents, and wish you a good afternoon, and I want to invite all of us for lunch. Mr. Osoro, when we are done here, we are very kind enough that we need to have lunch together. So don't run away from that. You are our friend, and so we want to prove that it was not a firefighting session between Council Tom and Wanjoy. Otherwise, I wish all of us a pleasant afternoon and a good weekend. So this session stands adjourned until the other time that will be scheduled. Honorable members, remain back for some housekeeping. Then Sergeant Atam usher our case to the lounge so that we can have lunch at that point. Thank you.